attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. This is the final segment in a four-part securities lawcast on the direct public offering process, including a Form S-1 registration statement. Today I'm going to talk more about the S-1 itself. The S-1 follows a particular format and order of information, including cover page, Part 1, which is the prospectus, Part 2, which is supplemental information, next is undertakings, then the signature and powers of attorney, consents, and finally the exhibits. Here is a brief summary of the most important parts. First, the cover page. The cover page of a Form S-1 contains identifying details about the offering and the issuer itself, such as the issuer's exact legal name, the issuer's state of incorporation, their SIC code, tax ID number, address and telephone number, and a little about the offering itself, including the amount of securities proposed to be registered, a proposed offering price if it's known at that time, and the registration fee. The next part is the prospectus. The prospectus contains specific information about the issuer, including a description of the company's business. The business description covers the prior 3 years for smaller companies, or from inception if the company is less than 3 years old. Examples of what must be included in a business description include basic corporate information, products and services, sources of raw materials, environmental issues, government regulations, research and development, and information about employees. The company must also include a description of future plans. For example, plans for expansion, to increase number of employees, for growth, and a discussion of the industry and competition. The prospectus part of the S-1 also includes a description of the securities being offered, as well as disclosures on the securities of the company, including, for example, prior markets or pricing for the securities, unregistered sales, activities, rights and preferences of preferred stock, rights and preferences of other classes of common stock, outstanding warrants, and dividends. The prospectus includes the management, discussion, and analysis of financial condition and results of operation, i.e. MD&A. MD&A often makes up the bulk of the narrative discussion in a registration statement and is arguably the most important portion of the registration statement for investors to understand the issuer and its management plans. A detailed discussion of MD&A could fill up multiple lawcasts itself. However, very briefly, MD&A requires a discussion of key financial elements and changes in those elements over time. For example, the issuer will discuss revenue and expenses and changes in revenue and expenses over a period of time, usually 12 months, and the reasons for those changes. In addition, MD&A requires a detailed discussion of the issuer's future plans and the costs and intended sources of financing for those plans. Also in the prospectus is a disclosure of certain information regarding directors, executive officers, key employees, and those that own 5% or more of the outstanding securities of the issuer. Part 2 of the Form S-1 contains supplemental information and formal legal requirements. Part 2 also contains the audited financial statements. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about any of the information we've just covered, please visit securitieslawblog.com or contact me directly. Inquiries of a technical nature are always encouraged.